The Karin Law and economic crimes. In Chile, the Chilean legal system is currently undergoing an unprecedented transformation, driven by a growing social awareness of the need to strengthen the protection of fundamental rights and the integrity of the economic system. This legislative evolution responds to long-delayed social demands and reflects a renewed commitment to social justice and economic transparency at all levels of Chilean society. In this context of profound institutional transformation, two legislations emerge as fundamental pillars of legal modernization: the Karim Law, which is 21/1643, and the Economic Crimes Law, which is 21/95. These regulations not only represent significant advances in their respective fields, but also symbolize a paradigmatic change in the way in which Chilean society addresses the labor and economic problems they have. The temporal convergence of these laws, which persisted for decades, responds to a particular historical moment in which citizens have significantly raised their expectations regarding the protection of fundamental rights and accountability in the economic sphere. This process of legal transformation takes place in a broader regional and international context, where various countries are strengthening their regulatory frameworks to face similar challenges, positioning Chile as a benchmark in the region in terms of legislative modernization. The simultaneous implementation of these regulations represents a significant challenge for all institutions involved, from regulatory bodies to the judicial system, passing through companies and organizations that must adapt their practices to the new legal requirements. However, this joint effort promises to generate structural changes that will benefit Chilean society as a whole. Let's start with the Karin Law, a revolution in labor protection. What is its genesis and historical context? The Karin Law, which came into force in August 2024, emerges as a direct response to a tragedy that shook the foundations of Chilean society: the death by suicide of Karin Salgado, a public official who experienced a prolonged period of systematic workplace harassment. This emblematic case, it not only highlighted the serious deficiencies in existing labor protection systems, but also exposed the urgent need for a comprehensive reform of Chilean labor legislation. Statistics prior to the implementation of the law revealed a deeply worrying picture. Studies carried out by the Ministry of Labor that indicated that approximately 30% of Chilean workers had experienced some form of workplace harassment during their professional lives. Even more alarming, only 12% of these cases were actually reported, and only 131.3% received a satisfactory resolution that adequately protected the rights of the worker concerned. The economic impact of workplace harassment was equally significant. Estimates indicated that Chilean companies were losing money annually, more than $500,000, due to absenteeism, staff turnover, and decreased productivity associated with workplace harassment. These hidden costs affected not only individual organizations, but the national economy as a whole, reducing the country's competitiveness and generating additional expenses in the health system. Public, we are facing a revolutionary regulatory framework. Let's comprehensively define, workplace harassment. The Karin Act establishes a revolutionary regulatory framework that transcends traditional conceptualizations of workplace harassment. The legal definition now covers a broad spectrum of harmful conduct, recognizing that harassment can manifest itself in multiple ways and through various channels, including the digital environment and corporate social networks. The new legislation defines workplace harassment as any conduct that constitutes repeated aggression or harassment exercised by the employer or by one or more workers against another worker or workers. That by any means and that results in harm, mistreatment, or humiliation for him or those affected, or that threatens or harms his employment situation or his employment opportunities. This definition is complemented by a comprehensive categorization of specific conduct that constitutes harassment, including systematic intimidation, manifested through veiled or explicit threats, degrading comments, or the creation of a hostile environment. The law specifically recognizes that these behaviors can occur both in the physical workplace and in virtual environments, including electronic communications and also social networks, social isolation in the work environment, which can materialize through deliberate exclusion from relevant meetings, unjustified restriction of information necessary for work, or limitation of professional interactions. The regulations clearly establish that these practices constitute a form of workplace violence regardless of their subtlety, interference with work performance, manifested through the assignment of impossible tasks, deliberate overloads of work, or deprivation of resources necessary for the development of functions. The law specifically recognizes that such actions, when systematic and directed, constitute a form of harassment that must be sanctioned. What prevention and control mechanisms? We find that we are going to compulsory prevention systems. The law establishes the obligation to implement comprehensive prevention systems in all organizations, regardless of their size or sector. These systems should include periodic psychosocial risk assessments, which should be carried out at least once a year, and after any significant incident, these assessments should use scientifically validated methodologies and be conducted by certified professionals in the field. Continuous training programs that cover all hierarchical levels of the organization. These programs should include both theoretical training on the legal framework and the consequences of harassment, such as practical exercises and simulations that allow workers to identify and respond appropriately to harassment situations, monitoring and early warning systems that allow potentially harmful behavior patterns to be identified before they escalate into situations of accelerated and declared harassment. These systems must incorporate objective and subjective indicators, including anonymous work, climate surveys, and analysis of absenteeism and rotation patterns. What about the complaint and protection procedures? The Karin Act establishes a robust system of complaints procedures designed to ensure the effective protection of workers' opposed rights. This system is based on principles of accessibility, confidentiality, and speed, recognizing the sensitive nature of workplace harassment situations. Complaint channels must be clearly established and accessible to all workers. regardless of their hierarchical position or contractual status. The law requires that organizations implement at least 3 different days for filing complaints, an in-person channel with specialized personnel, a secure digital system, and a confidential telephone line. This multiplicity of channels seeks to ensure that any worker can file their complaint comfortably and safely. The investigation procedure that follows a complaint must be completed within a maximum period of 30 business days, with the possibility of extension for justified reasons during this period. The employer is obliged to implement immediate precautionary measures to protect the alleged victim, including the physical separation of the accused when necessary, without this implying a deterioration in the working conditions of any of the parties. Protection and comprehensive support measures. Here we are talking about labor and legal protection. The Act establishes a comprehensive system of protection for whistleblowers and witnesses, including a guarantee against labor reprisals. Any form of discrimination or prejudice in working conditions, promotions, or performance evaluations is expressly prohibited. As a consequence of lodging a complaint or participating in an investigation for harassment at work, workers who report situations of harassment enjoy special labor jurisdiction throughout the investigation process and up to 6 months after its conclusion. This jurisdiction implies that they cannot be dismissed without prior judicial authorization, thus providing effective protection against possible reprisals. What about psychological support and rehabilitation? The regulations establish the obligation to provide professional psychological support to victims of workplace harassment with full coverage by the employer or the occupational health system. This support should begin immediately after the filing of the complaint and may extend until after the resolution of the case. According to the recommendations of the treating professionals, the rehabilitation program contemplates individual sessions and, where appropriate, group therapy with other workers affected by similar situations. Besides, gradual work reintegration programs are included that allow the victim to return to work in a progressive and supervised manner. We now move on to the Economic Crimes Act, transforming the corporate responsibility landscape. What are its foundations and scope? Law 21595 of August 2023 represents a comprehensive reform in the treatment of economic crimes in Chile. This legislation arises in response to growing social concern about the perception of impunity in corporate crimes and the need to strengthen the integrity of the national economic system. The scope of the Act is extraordinarily broad, covering not only traditional economic crimes but also new forms of corporate crime that have emerged with technological development and the globalization of markets. The regulations establish a regulatory framework that balances the need to maintain a business-friendly environment with the effective protection of public interest and stakeholder rights. Comprehensive regulatory framework. Let's talk about the classification of crimes. The law establishes a systematic and detailed categorization of economic crimes that includes, for example, crimes against the securities market ranging from price manipulation and the use of inside information to new forms of digital financial fraud. The regulations specifically incorporate crimes related to crypto assets and other digital financial instruments, violations of free competition that include not only agreements with traditional users, but also new forms of anti-competitive coordination facilitated by algorithms and artificial intelligence systems. Complex tax crimes with special emphasis on international evasion schemes and the misuse of corporate structures to avoid tax obligations. What is your sanctioning regime? It's a comprehensive diet. The Economic Crimes Law establishes a sanctioning regime that combines traditional punitive elements with innovative deterrence and reparation mechanisms. This multi-level system provides for sanctions that are proportionate to the seriousness of the infringement and the economic benefit obtained illegally. Prison sentences have increased significantly, establishing a minimum of 5 years for serious economic crimes and up to 15 years in cases of special seriousness or recidivism. These sanctions can be increased by 1 to 3 when the crimes affect a significant number of people or generate systemic damage to the financial market. Economic fines are calculated using a dynamic system that considers multiple factors, including the profit obtained, the damage caused, and the economic capacity of the offender. The law establishes that these fines can reach up to 3 times the profit obtained or 30% of the offender's annual sales, whichever is greater. What happens to compliance and prevention enforcement mechanisms? We're talking about internal control systems. Regulations require the implementation of robust internal control systems in all organizations that exceed certain size or risk thresholds. These systems should include compliance programs that integrate policies, procedures, and controls specifically designed to prevent economic crime. These programs should be regularly updated and subject to official annual independent compliance audits with sufficient authority and independence to effectively monitor the implementation of prevention programs. The law establishes specific qualification and experience requirements for these professionals and guarantees their autonomy. Through special protections against unjustified dismissal, we also have early warning and anomaly detection systems that use advanced technologies, including data analysis and suspicious pattern detection algorithms. These systems must be able to identify unusual transactions and potentially criminal behavior before they cause harm. Significant. And what about whistleblower protection here? The whistleblower protection system is one of the fundamental pillars of the new legislation. The law establishes robust guarantees for those who report suspicious or illegal activities, including, for example, anonymity guaranteed through technical systems and procedures that protect the identity of the complainant. The law establishes severe sanctions for any attempt to reveal or investigate the identity of a protected whistleblower. We also have financial incentives for whistleblowers who provide crucial information that leads to detection and sanction of significant economic crimes. These incentives can amount to up to 30% of the fines imposed, striking a balance between the need to encourage complaints and prevent abuse of the system. And how does this impact the national economic system? We are talking about a transformation of the business environment. The implementation of the economic crimes law is generating a profound transformation in the Chilean business environment. Companies are significantly strengthening their internal control and corporate governance systems, which is resulting in greater transparency in business operations. With a notable increase in the quality and quantity of information available to investors and stakeholders, companies are adopting more rigorous disclosure and reporting standards. We also have the strengthening of confidence in the market, evidenced by a reduction in risk premiums and an increase in foreign direct investment. International investors are recognizing progress in regulation and also control. And what effects do we have or find on competitiveness? The new regulations are generating positive effects on the competitiveness of the Chilean market, including improving the country's international reputation as an investment destination. Reflected in better ratings in international transparency and corporate governance indices, we also have reduced transaction and financing costs for companies that demonstrate high standards of regulatory compliance. And what challenges we face in the implementation and future perspectives. We are talking about challenges in joint implementation. The simultaneous implementation of the Karin Act and the Economic Crimes Act presents significant challenges that require immediate attention. The Chilean judicial system is undergoing a substantial transformation. To adapt to the new regulatory requirements, courts are developing specialized units to handle cases of workplace harassment and complex economic crimes, which implies a significant investment in judicial training and technical resources. Companies, for their part, face the challenge of adapting their structures. Organizational and control systems must comply with both regulations, requiring significant investment in technology, staff training, and expert advice. Medium and large enterprises are allocating 2% to 5% of their annual budget to these adaptations. And what progress and preliminary results do we find? The first months of implementation of both laws have shown promising results. In the workplace, there has been a 45% increase in complaints of harassment, which suggests a significant increase in trust in the protection system. 78% of these complaints have followed the new established protocols, demonstrating the effectiveness of the complaint channels that are being implemented. In matters of economic crimes, there is an increase of 60% in investigations initiated, with particular emphasis on cases of corporate corruption and environmental crimes. The case resolution rate has improved by 35%. Thanks to the new research mechanisms and the technological tools implemented, we are then faced with a cultural and organizational transformation. The most profound impact of these legislations is observed in the cultural transformation they are generating in Chilean organizations. Companies are taking more proactive approaches towards preventing workplace harassment. What about economic regulatory compliance? A significant change is observed in corporate governance practices, with 85% of listed companies implementing specific committees to monitor compliance with both regulations. And what future projections and trends we can see projections for the next 5 years? They suggest a progressive consolidation of the changes introduced by both laws. The Chilean labor market is expected to experience a substantial improvement in its organizational climate indicators, with an estimated 40% reduction in cases of serious workplace harassment. In the economic area, projections indicate a significant improvement in international perception of the integrity of the Chilean market. Country risk analyses reflect this positive trend, with an average 75 basis points reduction in risk premiums for Chilean companies in international markets. Conclusions and recommendations. We start with general conclusions. The joint implementation of the Karin Law and the Economic Crimes Law marks a turning point in the evolution of the Chilean legal system. These regulations not only establish higher standards of labor protection and corporate responsibility, but are also catalyzing a profound cultural transformation in Chilean society. Preliminary results suggest that both laws are fulfilling its fundamental objectives, that is, the creation of safer and more dignified working environments and the strengthening of the integrity of the economic system. However, long-term success will depend on the ability to maintain the initial momentum and overcome the identified implementation challenges. And what strategic recommendations can we give? To ensure the continued effectiveness of both laws, the following recommendations are proposed. First, institutional strengthening. The judicial system requires a sustained program of modernization and specialization. The establishment of specialized courts for economic and labor crimes is recommended, with judges and technical personnel specifically trained in these matters. And speaking of capacity development, it is essential to maintain a continuous training and updating program for all factors involved in the implementation of both laws. This includes not only judges and prosecutors, but also to employers, unions, and regulatory organizations, and we cannot forget monitoring and evaluation. It is recommended to establish a comprehensive monitoring and evaluation system that allows measuring the real impact of both laws and making appropriate adjustments when necessary. This system should include quantitative and qualitative indicators that reflect both direct results and broader cultural changes. And finally, what prospects for the future do we not find? The success of this legislative reform positions Chile as a regional benchmark in terms of labor protection and economic regulation. The Chilean experience can serve as a model for other countries that seek to strengthen their regulatory frameworks. In these crucial areas, the primary challenge in the upcoming years will be to keep the reform momentum alive while solidifying the achievements. This will necessitate continuous dedication from all social participants and a robust political determination to further fortify the rule of law and social justice in Chile.